Hi all, welcome to the second webinar on the new labor code. In the first webinar, we discussed about the overview of the entire labor codes, and the takeaway is the labor codes are more employee friendly, having fixed timeline of compliances, equal treatment among workers, and easy compliance. The role of inspector is now the role of facilitator also, and many other things. So those who are not viewed the video webinar of my overview of labor code, please look into that. In this edition, we will be specifically looking into the code of wages. As already mentioned in my first video, there are 4 codes. Around 29 earlier acts has been codified into 4 codes now. One is the wage code, and second one is the industrial relations code. Then is the OSH, that is occupational safety and health code, and SS code, that is the social security code. So we'll be looking each code in a separate webinar sessions. So this video webinar is dedicated to the code of wages. As you may know that there are similar laws already in existence with respect to wages. Is the Minimum Wage Act. You have 1948 Minimum Wage Act, which fixes minimum rates of wages, and you have very famous Payment of Wages Act 1936, which speaks about wages and of course various fines, deductions, wage period, etc. And you have Equal Remuneration Act 1976, which deals with parity among like workers has to be paid equal. So this Wage Code 2019 is a codified law, or the existing 3 laws, that is the Payment of Wage Act 1936, Minimum Wage Act 1948, and Equal Remuneration Act 1976, and also the Payment of Wages Act 1965. These 4 laws is being now codified into a single law. So to repeat, there are 4 laws already in parlance: is Payment of Wage Act, Minimum Wage Act, Payment of Bonus Act, and Equal Remuneration Act. Now you don't have these 4 laws because these 4 laws pertaining to wages or payments to the employees has now been codified or merged into a single law, that is the Code of Wages 2019. All the 4 laws which I mentioned has been repealed. So hereafter all the HR professionals and compliance professionals has to follow the Code of Wages 2019 and not the erstwhile Payment of Wage Act, Minimum Wage Act, Payment of Bonus Act, and Equal Remuneration Act. So coming to this law, let me first touch upon the structure of this law before we dwell into the details of the wage code. This has been demarcated into various chapters, which includes preliminary chapters, which includes minimum wages, fixing a floor price, that means the floor wages, and regarding pay cycle, and of course very important statutory or deductible fines, deductions, etc. from and workers salary part. Then the next part deals with the payment of bonus. Comparatively, payment of bonus is not that much altered from the earlier law. Comparatively, the computations and most of the areas is similar to the earlier law. And something relating to advisory body and audit aspect. If you ask me, the new law gives more emphasis on the accounts and audit to be updated in order to compute all the stuffs regarding to the payment. And then the piece of law specifies the role of the inspector facilitator, offences and penalty, and some miscellaneous provisions. So this is the overall structure of the wage code. Now few important areas which we will be discussing through this webinar, which you will be eagerly waiting, is regarding to the interpretation of wages, employer, employee and all. We will be shortly looking into it. Yes, we have separate definitions for employee, worker, employer, wages, minimum wages, appropriate government, and of course few other important terms which will decode in this webinar. So any queries you have, please put as a comment so that I can give you a reply whenever time permits. Now the first and most important interpretation with regarding to the wage code is regarding the term employee and employer. See, most of the definitions in the wage code has been uniform across the codes. Most of the definitions, not all definitions, but most of the definitions. So the same definition can be used in different codes. So that is again a very interesting part, because in the early law each act has its own definition for the term employee. But in the new codes, the labor codes, most of the terms can be similarly used in the various codes across the codes, except specifically mentioned. So coming to the definition of the term employee in the wage code 2019, which is a very broader definition. It is wider in scope than the erstwhile definition in the Payment of Wages Act. So I will highlight the main changes here. If you read the definition, you will see the similarity of the framework of the definition, because the same way it was crafted in the earlier old law, the method or the framework of the definition is same. But you will see few additions or widening in the scope of the term employee. To be specific, in the new definition, the terms supervisory, managerial and administrative category has been included in the term employee. What does it mean? It means, as per the wage code, the employee is not limited to workers, not limited to the erstwhile interpretation like workers who do manual, operational, clerical work, or skilled or semi-skilled or unskilled works. Rather, now the new definition is more broader to bring supervisory, managerial and administrative category employees also under the ambit of the definition of the term employee. So what does it mean? It means that the protections available in the wage code, or the new initiatives available in the wage code, especially redressal machineries, and of course the machineries to take up the matter, escalate the matter to the higher levels, and in nutshell, the employee friendly initiatives in the wage code is now applicable to the supervisory and managerial administrative category employees also, like general manager or deputy general manager or manager. So this is going to be a very important takeaway as far as the wage code, or as far as the HR concept is related to. Because usually we have a connotation that the Payment of Wages Act and most of the wage related laws is applicable only to the workers category. But the new law, since the ambit of the term employee has been broadened, now the senior management employees of a company or an entity will also get the protection under the wage code 2019. So that is going to be a sea change in the interpretation of the term employee. So all the HR professionals and compliance professionals has to look into this aspect very very keenly, because now the senior management employees of an entity will also get the protection under the wage code. So like appointment letters, all the things which we usually discuss in the new labor code, inspector facilitator assistance, and of course the protections related to the wage period, the time limit of payment of wages, especially in the case of termination or dismissal of employees. All these protections will now come handy to the managerial staffs also, that is the management, senior management employees also, apart from the workers. So that is the main change you have to take into note. Now coming to employer definition also, there is a very interesting new clause added. Usually employer, we denote to the establishment. If it's a company, then the company. If it is a firm, then it's a firm, or LLP, it's an LLP. But in the new definition, they had added something called as who are in the control of the affairs of the establishment. Those people who are in the control over the affairs of the establishment will also come under the ambit of the term employer. So coming to a company, company is being structurally administered by or controlled by the managing director of the company. In the new law, the managing director of the company will be interpreted as the employer apart from the company also. So this is going to be again a very important change, because whenever there is a dispute or litigations before the court of law, the honorable court can also held responsible the managing director of the company or those people who are entrusted with the management of affairs of the company. So the definition is now a little bit broader as far as the term employer is concerned. So the term employer will now cover, the managers of the entity, the managing director of the entity, because the definition is broader in the sense that whoever is administratively control the affairs of the establishment will also come under the definition of the term employer. So this is again an advisory takeaway, because you have to advise your concerned, top management, MD, manager, etc., that any labor law violation, that is especially with regarding these new codes, you will also be held responsible. Now the most important definition, if you ask me, of course in the Payment of Wage Act also, and the erstwhile Payment of Wage Act, now the new law, that is the Wage Code 2019, the term wages. Structurally it is same. If you look the structure of the definition, it is same like what you have in the Payment of Wage Act, but little bit more additions has been brought in. So wages, of course, the same structure as I told, means all remuneration, whether you call that is a salary or allowance or otherwise, and also whether it is express or implied, etc. And it has an inclusive list, and also it has some exclusive list. Inclusive list, all the HR professionals will know that basic pay, dearness allowance, retaining allowance, etc., but does not include bonus, HRA, and all things. So most of the structure is same like what you have in the Payment of Wage Act. But here something new concept has been introduced with regarding to the term wages. You have certain things which are inclusive, that is basic pay, dearness allowance, such other allowances, and you have exclusions. Bonus will not be form part of the wages, medical allowance, house rent allowance will not be form part of the the term wages, and this is nothing new because it was already there. But here the main change, for example, PF pension contribution will not be included in the term wages. So there are certain terms, certain entries which are included in the term wages, and there are certain entries which are not included or excluded from the term wages. That is there already in the law. But what is new in the wage code is they had included a rule called 50% rule. So this 50% rule is regarding to the deductions. So first I will read the provisions for your easy interpretation. Provided that for calculating the wages under this clause, if payments made by the employer to the employee under A to I exceeds one half of such percentage of the all remuneration calculated under this clause, the amount which exceeds such one half so notified shall be deemed as a remuneration and shall accordingly added in the wages under this clause. So this is the 50% rule. So that means you have basically a wages interpretation, which is obviously the salary part. And what is salary? It is been included there. It is the basic pay, it's a dearness allowance, and such other addable allowance. Then you have some exclusions: bonus, PF, provident fund, medical allowances, HRA will be excluded. Yes. So now you will have an amount. Now the question is what you have excluded. So if you compute the total exclusions in a figure, in an amount, and if this exclusion is exceeding the 50% of the wages of a wage period, then the included amount above the 50% will be part of the remuneration. So this I will again explain the 50% rule here. The scope of definition of wages has been now been widened, and there are list of inclusions, there are list of exclusions. So you must look into the exclusions list, and you can exclude many things. Of course, these exclusions should not be more than 50% of the total wages. So the ideal situation will be 50-50. That means 50% should be inclusions and 50% should be limited to the exclusions. You got my point? And if the exclusion is more than 50%, say for example 60%, then the 10% will be form part of the wages. So that means you have to again control the total exclusions or deductions within the limit of 50%. So this is going to be a very important interesting part in a layman knowledge. The takeaway of an employee per wage period will be at least minimum 50%. Am I right? For example, say assume that for example 30,000 is just an example. 30,000 is a worker's or an employee's remuneration for a particular month. Gross remuneration. Now you will go on deducting it. You will deduct HRA, you will deduct medical, you will deduct PF. There are other deductions you all know in the payroll. So that deduction should be limited to 50% of the wages or remuneration in our example. So in our example, 30,000 is the gross. The maximum deduction should be limited to 15,000. So that means an employee, his salary is 30,000 per month, but he will get at least 15,000 because as per the definition of the term wages, the total exclusions from the wages should be limited to 50%. But if in a particular scenario, if it exceeds 50%, say 55%, 60%, 70%, there are more exclusions than more than that portion from 50%. That is, the excess from the 50% will be interpreted as remuneration only. So that means in strict law, you have to limit the total deductions, total exclusions from the wages up to the limit of 50%. So this is the 50% rule. So in my example, simple 30,000 rupees if an employee is getting his remuneration, that is the gross remuneration. As I told, there are inclusion and exclusions. Yes, you had 30,000 rupees as a gross. That means you are included everything. Now you are going to start excluding medical benefits, all other insurance premium, whatever maybe you are going to start excluding. That exclusion should be limited to 50%. What is the interpretation and what is the takeaway for an employee? Out of 30,000, he will at least get 15,000. That is the 50% as takeaway or take home, whatever may be the interpretation. So this is a very important aspect as far as payroll computation for the finance and HR professionals concerned, because in any excess beyond 50% deduction will be again treated as a part of remuneration. That means you have to pay as part of his remuneration. So this is the 50% rule of wages, which everyone should be very careful about. Now coming to worker. Here also, I think not that much constructively changed, but there are some more additions. As you may have read in various social media, newspapers, that the ambit of labor code has been widened. Apart from the unskilled, skilled, technical, operational, clerical workers, now working journalists and sales promotion employees will also come under the ambit of the term worker. That is why the aggregators, which I discussed in my first webinar, all this Swiggy, Zomato, all Blinkit, all type of employees will also come. Also, sales promotion, marketing executives, you will see a number of marketings will also come under the definition of the worker. And also, you should interpret that any person who is being dismissed, discharged, retrenched, or terminated, etc., consequence of a dispute or etc. And after that also, he will be called as a worker, so long as his amount is being settled. Because there was some interpretations where whenever you go for a litigation after an unjust dismissal, and after the dismissal, usually when there is a dispute, it's very difficult to call that particular person as an employee, because he is no longer an employee, because you are dismissed. So there is various interpretations or discussion with regarding to whether the benefits of a person as an employee is lost when he is discharged or dismissed or retrenched or even terminated. So that is why the new law is intact, maintained a view that the term worker will also include such persons who are dismissed, discharged, retrenched or terminated consequence of a dispute. So that means the takeaway is, so long as you settle the entire obligations of the employer with respect to the particular worker, he will be continued as to get the protection of a worker, continued as a protection or the interpretation of the term worker, even though he is dismissed or discharged or retrenched or terminated. So that is again a very important aspect every HR professional and compliance professional has to look into. So now we had discussed about very important terminologies with regarding to the new wage code, with regarding to the term employee, employer and wages, and also the term worker. Now we'll of which we discuss, obviously the 50% rule is very important, and second one is with regarding to the employer, the manager or the managing director of the entity will also come under the bracket of the term employer, is very important as far as I am concerned. And of course there is a very transparent provision with regarding to the gender wage discrimination. You all know in the first webinar I specifically has been discussed with regarding to this, that this provisions regarding to wage code and all these things has given more importance to parity, gender parity. So this law, if you closely look, you will see many criteria with regarding to the gender parity. Same work or similar nature work, you have to pay equally with regarding to a male worker and a female worker, because you should not discriminate. So task and it will all depend upon the tasks and responsibilities fixed upon, skills and qualifications and efforts and performance expectations. But to be very clear, if it is the same work or a similar nature work, then you should not discriminate with regarding to the payment with respect to the workers, either it is a male worker or it's a female worker. So employer will also has to take some actions regarding to adopt equal pay policy and publish that to the information of the employees in general. Conduct regular pay audits and rectify any gaps wherever in a particular category or cadre or a grade. If there is any difference between a female worker or male worker, then you have to the amount has to be, you have to rectify the gap. And use transparent job evaluation, especially when you have screening, recruitment or employment aspects, all the HR interviews and all. You have to make sure that you have a clear-cut equality criteria for both male and female worker. And of course, you should ensure fair recruitment promotion practices. You should not discriminate between in the aspect of gender. And make sure that ultimately the wage codes which is being introduced by the government of India gives utmost importance to the wage equality as far as male worker and female worker. Now coming to very important aspects, now we will move to the employer's duty for minimum wages. So as you may had already known that the new wage code has a clear-cut framework as to the minimum rates based on different criteria. One thing let me like to highlight you, that the Payment of Wages Act, the earlier Payment of Wages Act, has a monthly limit of INR 24,000 rupees, and most states that was the limit, because the Payment of Wages Act is applicable only to an employee who draws a salary up to rupees 24,000. the present law, there is no such limit as on date. As on date, there is no such limit. That means this wage code will now, since the wage code does not prescribe this wage limit, threshold limit of 24,000 in the present wage code. So that means the senior management employees or the executive managerial employees will also now cover under the benefit of the minimum wages laws or the wage code, which we are discussing. So this is again important takeaway. Maybe we have to see the rules to be notified if any limits is been brought into or not. So long as there is no such limits has been brought, so that means it's very clear that the wage code is applicable to the senior management employees also, like workers, because there is no such 24,000 per month limit for the wages as far the present code is concerned. So that is a very important takeaway for the HR, PR, personal management professions is concerned. So as you know, the way the new code has a specific initiative to fix various minimum rates based on skill of the employees, skill sets of the employees, and second one is based on the geographic specific rates, and third one is based on very hazardous workers or employment is concerned, that there will be different rate. And of course, the central government will fix something called as the central floor rate, that is the minimum rate, which will be notified through rules. So as a HR professional or compliance professional, we have to look in the particular industry in your if your entity or a company is pertaining to whether there is any floor wages fixed by the government, appropriate government or not. Point number one. Point number two, and you have to check the skill, whether it is a skill based rates or it is a geographic basic rates, or if you are a hazardous industry, then what are the adjustments you can make. So this slide is very important as far as the actual computation is concerned. You make sure that whether there is a floor rate been fixed by the government or not, and that is been fixed on the basis of the skill set, which will be notified by the government for each particular domain, and of course geographical based also. So on the basis of that, you have to fix the wages of each category of employees. Now the duty of minimum wages payment will continue as I told, role to rate mapping. So on the basis of skill or on the basis of the role played, you have to check a particular category of employee and what will be the minimum wage you have to give. And payroll validation, there is something called as there should be a clear mandate as to what should be the minimum wage you have to pay on an hourly basis, on a daily basis, monthly basis, piece rates. You have to look into the rules which will be notified shortly, and of course you have to monitor in the government notification. I think many people ask me personally that how we have to update this. So you have to regularly get updated with regarding to the rules notified and the rates notified, because the wage code is only a parent law, because the substantive law will be in the rules and the notification issued by the Ministry of Labour and Employment. So please look into that on a regular basis, because you have to look into whether your industry or a company or entity falls under particular notification, then you have to comply with the same. So this is again with regarding to the employer's duty to pay the minimum wages. Now will you ask me, sir, what are the components of the minimum wages? And if you look, it's more or less same like the Minimum Wage Act and read with the Payment of Wages Act. There is not that much difference in this. So if you look into the structure, yes, you will have a basic pay. Basic pay you will fix for a particular industry, particular domain, and you will have a dearness allowance that we call as a COLA, the cost of living allowance, and you will have a component of the cash value of concessions you will give for the benefits and of course the concessions you give. There will be the cost factor for that, and there will be something called as an all-inclusive wage rate. So if you see this wage structure is more or less the same like already existing in the Minimum Wage Act 1948. There is not that much changes in use. So you can fix the minimum wage in 4 methods. I should say it's not 4 method, it's basically a 2 category method. One is you have a base wages, added to that is the cost of living allowance, that is the DA, and next one is the cost of concessions. That is first method. And second one is, in order to apart from splitting that into different category, you can compute or you can fix an all-inclusive wage rate. Inside that, everything, the aspects regarding to the basic wage, the dearness allowance and the value concession will be included. So nothing new here because it is already there in the existing law. Now coming to fixation and revision procedures, mostly similar to that of the earlier law, but there is some changes. Basically, you have to, the government will or the stakeholders will initiate some proposals, and the proposal will go to a committee, and the committee's recommendations with regard, it will be put in a public consultative paper, and there will be a lot of consultation with regarding to the amounts and all. With regarding to the employer association and employee associations and all, all the trade union, then the rates will be notified and that will be effective date. So how does you are going to fix the minimum wage will be based on a consultative process. And if you see, the most of the procedures here is same like what were already there in the Minimum Wage Act, where there will be some proposals, maybe a lot of proposals for each industry, for cement industry, for chemical industry, for IT industry, for electronic industry, for hazardous products, etc. And that will be, all the inputs will be taken up to a committee, and the committee will conduct a lot of consultative process with the trading associations and all. Then it will have a notification with the rates, and they will also fix a separate date of notification. From that date, the minimum wage will be get into force. So structurally, this is a little bit an administrative process, how a minimum rates will be fixed. And it's not only fixing, we have to revise that as per the time reflection of time. You have to change the wage rate regarding to the cost of living allowance also. Now coming to normal day and working times and all, basically the appropriate government will come with the rule with regarding to what is a normal working day. We have to wait for the rules. I think already the draft rule has been rolled out in 30th December. We will decode that in subsequently. Then when an overtime trigger will happen, any work done above the normal working day time is called as a overtime. Say for example, if overtime, for example, a normal working day, if it is been notified as 8 hours, so any employee or worker working above 8 hours, and that above hours will be called as the overtime. So overtime trigger. And employer obligation is whenever a employee or worker is supposed to work for overtime, then a written authorization has to be taken from him for overtime working, and ensure the proper timekeeping record, because you all know, whenever you prepare a payroll, you usually compute all this. Already you will do this, you have been doing this. Then there is a concept of rest day entitlement, because you cannot expect an employee's workers to continuously work, so there will be intermittent rest days. And the rate for overtime is already there in the earlier law also, twice the normal wage, normal working day rate. So if normal working day rate is, say, assume that it is 500, then for overtime you have to pay 1000, because twice the normal day rate. And there are some exemption and emergency work criteria also. So all these things will we have to see when the rules is be notified. So the present code says that this appropriate government will fix a hour, saying that normal working hour or normal working day. Any work arrangement beyond this normal working day will be treated as overtime, for which the employer has to pay twice the rate. And mind you, while you engage a worker for overtime, you have to get an authorization, written authorization from him. And second, you have to keep the time keeping, record keeping, in a very clear, crystal manner. And of course, there should be a rest period in between normal working days, which the days will be notified later. And there will be some exemptions with regarding to some, emergency work and all. So we will see when the rules is being notified. More or less same like in the earlier law. Now coming to payment of wages, modes and wage periods and all, mostly are similar to that of the earlier existing law. If you already you have been practicing this, nothing major new changes has been brought into the wage period and of course the wage modes payment. Yes, wage payment mode is of course coin, check, bank credit, electronic mode. Even though presently also you people were being paying through electronic mode, but in the parent law, like Payment of Wage Act or Minimum Wage Act, there was no such mention because it's a very old law, 1936 and 1948 law. But in the new law, the parent law itself has allowed you to pay the wages or salary through electronic mode. So that is one change. Wage period, like same like in the earlier law, you have various options. You can have a daily wage period. Second one is weekly, and third one is fortnightly, and fourth one is monthly. So you have 4 wage periods. You can employ a person on a daily basis, on a weekly basis, on a fortnightly basis, and on a monthly basis. Okay. So this is regarding to the wage period. And there should be clear wage policy by the HR department, labor, talent acquisition department, or we call as HRD department or personal management department or IR department. Whatever name you call, you should have a clear HR policy which specifically says what are the wage periods you have and what are the wage payment you will methods you will make. So then of course issue wage slips and maintain payroll records. Wage slips is mandatory. You have to issue wage slips from your payroll software mostly to all employees, all workers. And adopt secure electronic payment methods, and you have to help the employees with bank account setup because now since the electronic payment is now legalized through the act itself, that is the code itself. So there may be workers who are not acquainted with that electronic payment system. Then you have to assist the workers to enable bank or electronic payment systems also. So you have to help them. So not much change, but electronic mode now is been brought into the parent law itself. And wage period is daily, weekly, fortnightly, monthly. Now very interesting here is with regarding to the time limit for payment of wages, actual payment of wages. As I told, we have 4 categories of wage period: daily wage period, weekly wage period, fortnightly wage period, and of course monthly wage period. So what is the time limit for payment of wages? Else it will be, if you not pay within the time limit, then you will be attracting the penalty provision. One is daily wage, of course, at the end of the shift. So if you are having an arrangement of daily wage period, then after the wage period is over, like evening or what, you have to pay the worker. So you cannot keep to the next day or the next coming days. So you have to immediately settle it after the wage period, daily wage period is over, maybe after the normal working day is over. Second one is weekly basis at the last working day of the week. So again, that means after the wage period is over, you have to pay. Like Monday to say Saturday, if it is the wage period, then Saturday evening you have to give the salary or remuneration or wages for that particular weekly basis work at the end of the last working day of the week. So this is again a very important concept. So at the last working day of the week. So that will all depend upon from which day you are employing him. So whatever may be your weekly arrangement, is better you pay after conclusion of that wage period. The law says at the last working day of the week. So assume that the wage you employed him, say on Wednesday, so for a period of 7 days, so that means next Wednesday. So Wednesday evening you can give, or you can give on Friday, the Thursday or Friday, or even Saturday, because Saturday being the last working day of the week. So that will all depend upon how you are arranged your week. So the law is very clear, at the last working day of the week. So weekly settlement, you can say. Next one is fortnightly, that is 14 days work. Then you have 2 days time to settle them within 2 days. So very sharper provision. So you cannot make, usually, practically, if you employ a worker or X number of workers for a fortnightly basis, the wage date will come on the next first day, right? Like September 15 to October 15. So the next wage date is usually in a payroll concept will come on the November 1st week. So you cannot now you cannot wait till November 1st week, because as per the law, for fortnightly work arrangement, you have to pay the wages for that particular workers within 2 days of conclusion of that particular fortnightly time limit. So again, a very sharper provision. Monthly wage, there is not that much, difference, 7 days time. But still, you all see many industries are there which pay on the 10th of the succeeding month. So it is not possible. Now the statutory time limit is for a month, monthly work. The succeeding month, you have to pay within 7 days of the succeeding month. Like for example, October 31st is the wage period is over, then you have to pay the wages for that particular period within 7th of November. So this is again a very clarity over the law. So I repeat again, the wage period and wage limit, that means the wage time limit to pay the wages is daily at the end of the shift, weekly at the last working day of the week, fortnightly within 2 days of conclusion of that fortnightly, month within 7 days of the succeeding month. So this is a very important provision. The most debatable and most discussed provision in the new code is the 5th one. I think many HR professionals or even practitioners also will be concerned about this, because when there is an instance of removal of worker, or a worker or employee is resigned or dismissed or retrenched or due to or closure, you have to settle that within 2 working days. So this is a very, I think, most stringent provision in the wage code. I don't know how many people are feeling it practically difficult. The most maybe resigned people will be happy, because usually resigned people has to hang over there to get the balance salary and all. So as far as them is concerned, it's a great relief. But dismissal also, that is very interesting. When you dismiss an employee due to a disciplinary proceedings and all, make sure that once you confirm the dismissal, within 2 days you have to settle him all the wages they earned in the wage period. So this is going to be a very interesting topic in coming days, because of the practicality there. So any employee, worker who is removed or resigned or dismissed or retrenched or removed from the organization due to closure of the establishment, then you have to settle pay the wage payment, pending payment of the wage period, pertained wage period within a period of 2 working days. I should say settle not the retirement or other terminal benefits, but usually we interpret here as the wage benefits. That is the wages pending for that particular wage period, or a wage period he has been working for quite a long time. For example, a person has been dismissed or terminated on, say, for example, August 15th, say August 16th, for example. So his termination or his resignation is with effect from August 16th. Then within 2 days, that means 17, 18. August 18, you have to settle the August month's salary, because August month is already due. There is a 15-month salary for him. So you have to settle that within 2 days. So again, these type of new provisions is a hit on the compliance door as far as a entity is concerned. The HR professional has to make sure that you comply with this in true letter and spirit. Coming to deductions area, as you will remember, the Payment of Wage Act, there is a list of deductions in the 1936 law. Here also there is a list of deductions, and not that much change. You can just look into it. Deduction categories is, of course, fines, penalties, absence from duty, LWP, what we call, recovery from damage of employer property, yes, repayment advance of loan from the employer, statutory deductions, you all know, you have subscriptions, payment, PF, all the things. And the limit is very important. Total deductions capped at 50% of wage period, as I already told. Now the entire deductions is limited to 50%. And of course, so make sure that you have to limit at 50%. Any excess to 50% will be part of the wages. Employers must, of course, pay payroll. Everything has to be specifically, stated in the payroll. Not much change from the earlier law. The earlier law also like this. So there is not much change concerned. Now there are some safeguards with regarding to fines. Just to have some insight into it, because the law went to make sure that the employer does not put more hardship on employees with some unauthorized fines and deductions. So that is why we make sure that there is some more transparency in this process. One is, whenever you charge specific fines, you have to have a approval before the imposition of fine. So prior written approval for specific fines is mandatory, and damages, you can deduct from the workers regarding any damage to the assets of the entity. So now that is limited to the actual loss, not to the opportunity lost. So actual loss, whatever be the damage cost, you have to make a valuation on that, and the actual loss only can be deducted. And regarding to disciplinary rules, the employee should have clear idea about what disciplinary rules are in place. So he must already know that if you violate a particular conduct, then he will be charged a fine. So make sure that you inform the disciplinary proceedings or disciplinary matters or code of conduct to the employees well in advance through some notice. So in a way that employee must be known that this is a particular misconduct had happened. So only you can charge penalties for that disciplinary actions which is already known to the employee. And you have to maintain a register of fines and deductions. As you know that there is an inspector cum facilitators acting here. So whenever there is an inspection, you have to produce these type of register of fines, especially when there is a dispute. And before you charge a worker with fines and deductions, make sure that you give a written show cause notice and an opportunity of being heard on the basis of the natural justice. And unless and until you get an explanation maybe from the workers of the company, you cannot keep him in dark with unauthorized deductions. HR to document and ensure rules and ensure fair processes. So everything has to be documented, everything should be displayed. So make sure that you follow a robust system in the entity. Otherwise, when there is a dispute, the question of unauthorized fine will be challenged. Absence deductions proportional to hours lost, calculate deductions based on actual hours lost. So when you as far as hourly based and weekly based employees is concerned, when their remuneration is computed on the basis of hours worked. So if you want to deduct on the basis of absence, then you have to deduct on the basis of the actual absence hours, not like full day deduction, 2 day deduction. You cannot do that. The actual hours should be computed, and that proportionately that hours can be deducted from the working hours. So absent deductions proportionate to the hours lost. So loss of pay, whenever on an hourly basis work, you can compute the loss of pay on the basis of the hours lost actually. So not the entire day or entire in a couple of days. So again, we have to wait for the rules to be more particular about this. But you will closely, if you are an experienced HR people who are looking into the labor law compliance, and of course the payroll is concerned, you will feel many instances there is some clarity. And if you see, it puts the new wage code puts your responsibility on you to be more documentation, on you more fair process. And of course, whenever you charge a penalty or fines for an employee, make sure that you give proper show cause notice. So unauthorized fines and reductions is not allowed in the new wage code. So make sure that you have a proper compliance. And recoveries more or less same on in the line with the earlier laws, not that much change, but there are some additional provisions with regarding to the recoveries. Pre-employment advances recover only the first wage period, yes. Other advances recover with prescribed condition. Welfare reductions, government by same clause. Maintain return loan agreement. So this is again an important part. So whenever you deduct installments of loan agreements from an employee's for a loan taken by the employee from the employer or some cooperative society and all, make sure that the HR department or the payroll department have a copy of the loan agreement, because due to the fair practices principle, you have to maintain the details of that also. And keep a clear repayment plan, so the installment or EMI schedule should be there, and you have to clearly vouch that same. Obtain payroll reduction authorization from employee. Whenever you reduce any loans and advances from the employee, make sure that you take a authorization form from the employee, so that later on there should not be any dispute. Align records with notification of the code. See, always you have to look into this code, and the notification issued by the central government from time to time. Make sure that you properly. So if you ask me, for the recovery process or loan recovery process and all, there is more fair practices introduced in the code. More documentation emphasis is being given more to the documentation, file management and all. So there were times where you usually deduct anything, and the employee comes to the HR department, and you keep on him standing, having some dialogues and all. Usually there's some practices. Now nothing will happen, because everything you have to, any deductions, recovery has to be documented with the prior consent of the worker concerned, so there is no ambiguity. So ultimately, the intention of the law is to have a good industrial harmony. There is a good relation between the employer and workers, so that more emphasis is given to the employee welfare and a good harmonial we'll say environment. Now coming to wage, apart payment of bonus. We had already completed and touched the main provisions regarding to wages, wage period, deductions, and minimum wage fixation and all. Now, since the Payment of Wages Act also is being merged with this code, you will be eagerly waiting for the bonus. See, if you see bonus, the most interesting thing is there is no change, much change I should say, from the Payment of Bonus Act 1965. The minimum bonus and minimum rate, everything is kept in same. So 30 days accounting year working, you all know that, the same law. Percentage is 8.33% to maximum 20%, same bonus rate. And the minimum amount is 8.33% or 2 or 100, whichever is higher, same rate. So basically there is no change in the minimum bonus and maximum bonus rates, and of course the eligibility criteria of 30 days working also, no change. Now the $1 million question is regarding to the limit. The present law says 21,000 per month monthly wage limit for eligible for bonus. In the present law, presently there is no such reference to this threshold limit of 21,000 per month. So we have to wait that the appropriate government will change this wage limit or notify the particular monthly eligibility limit. So far as there is no notification, you can continue with this 21,000. Okay. So many people ask me that whether you have to follow this 21. Yes, since there is no new notification, you have to follow with the old one, that is the 21,000 per month. So we will see if there is any change regarding to this 21,000 notification. Maybe government may increase it, or we will see. Presently, there is no mentioning. It's not notified by the appropriate government. So we will continue with the 21,000. So workers coming under the 21,000 salary base will now attract the bonus like the same law. We will see whether any notification regarding to the increase of this amount. So long as there is no fresh notification, please maintain a status quo as per the present prevailing procedure, that is the monthly salary base of up to 21,000. Computation part of bonus, again nothing much change. I think nothing to the computation of available surplus, allocable surplus as per the earlier law in the payment of wages, payment of bonus act 1965. Not that much change. The same like gross profits, available profits, bonus pool, less prior charges, allocable surplus, and finance to payroll workflow. I think nothing to discuss here because most of the provisions regarding to and set of procedure there was already there in the earlier law regarding to the set on and set of procedures. And 20% cap, if you have an excess, it can be set off to the next year. So all the same principles will apply to the present law also. So we need not want to discuss it further. Coming to some disqualifications for bonus. In the earlier law, there was some disqualifications. Here also little bit changes has been reduced. So disqualification criteria for annual bonus is fraud, of course, violent behavior, theft, conviction for sexual harassment. So that is a new area. You all know POSH law and your internal committee and all. So any employee or worker who is convicted of sexual harassment will be disqualified to get a bonus for that particular year. So that is a new aspect which has been introduced. Partial year work, proportionate bonus reductions for part year service, compute bonus pro rata for partial year employment. I think in earlier also we used to compute part year only. If an employee has a part service, then you will compute the proportion basis. If you are not doing so, then hereafter please make sure that part year completion you will compute the bonus on a pro rata basis. Included working day categories, leave with pay, maternity leave counted as working days. Included paid leave types. I think earlier also there was there, leave with pay, that means paid leave, and maternity leave is also computed for the purpose of working days for a bonus. Payment deadline, I think there is no change. Earlier also there was 8 months time period. Extension allowed up to 2 years in sufficient cause, sufficient reasons. In the present law also same. So whenever I used to take sessions on, training sessions on this new labor code, on a lighter note, what I had seen is many people, especially maybe the junior level HR people, they keenly take note of all these points. Like for example, the payment of bonus deadline is 8 months and maximum 2 years. Many provisions which we discussed today. And whenever I see they are keenly writing it, write down it, I used to surprisingly ask them, why are you writing that? So they say that, they want to remember that when they apply, because they don't know that these were already there in the earlier law. So that is a very interesting part. Many provisions, today I discussed, many provisions are already there in the existing law. So that's why I am emphasizing only the new things. In bonus, especially bonus act, most of, I think 90% of the bonus law, which is already there, has been replicated to the wage code, like, 8 months time period, and the maximum extension to period, everything, and many things, minimum base rate, minimum bonus rate, maximum bonus rate, everything. So I like to request new, HR professionals to make conversation with all these basics, so that, and I would also appreciate if you please read the earlier law, so that the new law conversion or transition will be very easy for you. Okay, I've told it on a motivation note, not on a negative note, please. I think more or less it's over. Now some advisory boards and central state boards, which is purely an administrative angle. There is a central statutory advisory board and state statutory, state advisory board, basically to administer the law. There is a tripartite membership in this from representatives from employers, representative employee, and independent persons. And after which 1/3 members will be women, workers. Boards advise on minimum wage and women's employment, employer and HR engagement opportunities recommended, and all these things are purely on administrative things, which we will discuss, maybe after a later date, because we have to see that how this wage code is going to be in a mature level of compliance. So administratively, there are many initiatives taken, more or less on a collaborative angle. Representatives of employees and workers, trade unions, and of course, more, representation of women workers have been induced in all these administrative boards. So that means the entire interest of the workers will be taken care of. So administrative angle we will discuss, we will take it up maybe after a matured, since it's hardly 1 month the new law has been implemented, we have to wait for the rules, and we will see maybe after 6 to 7 months how this been spanned out, and then we will be discussing about the administrative mechanism. Coming to dispute resolution, every code, I think, wage code, and of course the IR code, and of course OSH code, and of course the SS code, all codes have separate mechanisms for dispute resolution. So filing of claim, compensation, recovery, enforcement, authority hearing, appellate route, employer obligations, and all. So these are things, are practical aspects when it comes to after this law is been fully implemented, maybe. So we will, all these things we will discuss in a separate, maybe after a 7 months or 8 months time. So now the present job is to clearly understand the present law, especially with respect to the new changes which has been introduced in the new law. Audit presumption. So here I think one point I like to highlight is, see, whenever it comes to the wage period, wage computation, wage payment, bonus computation, deductions, all these things in the present law gives more emphasis on the audited accounts of the entity. So I think the finance people of all the entity, maybe it's a big sized entity or a micro or a medium or small enterprises, make sure that your audit is updated, your accounts is updated, and your audit is updated, because all the computation will be based on the latest available audited financial statements of the company. So audit presumption, authorities may presume accuracy of audited balance sheet and P&L account. So that is very important. Audit direction power, authorities can direct audits of non-corporate employees, because as far as company is concerned, it's mandatory. But there are many entities where it is the statutorily they need not want to conduct audit of their accounts. In that case, the authorities under this code can compel them to conduct an audit, because all computations, all especially with regarding to gratuity, regarding to bonus and everything, all will put the wage structure, which is the wage revision, wage structure, all the things is been based on the audited accounts of the entity. You will appreciate that. So make sure that the accounts is updated and it is reliable, so that audit has to be mandated. Keep audit records, maintain audit accounts and supporting document schedule. Prepare clarifications, finance and HR to jointly read explanation and unit responses. Practical step, document bonus methodology and source data. So regarding to computation of wages, regarding to computation of bonus, including gratuity, all the payments structures, I would advise the entire HR professionals to make sure that advise or you coordinate with the finance department that the figures which you take should be from the audited figures. Even though if your entity is a non-corporate entity where audit is not mandatory, the labor authorities or the authorities under the code can ask you to audit your accounts, because the base computation, of course the gross profit computation, the deductions computation, net profit computation, available surplus, allocable surplus, all things are based on the financial statements of the company, which should be audited, which should be reliable without beyond doubt. So unless and until it is been reliable, or there is some difference of opinion, then the entire computation will go wrong. So I think audit provision is also here important. And coming to some additional compliances under the wage code, maintain required registers, employment details, must roll wages. You're already doing that. Display mandatory notices, abstract, categorize wage rate, wage period. All the wage period, wage rates, everything has to be displayed for the employees and workers for information. Show inspector cum facilitator contact on board. So this is very interesting. You have to give the contact numbers and contact details of the respective inspector cum facilitator in the notice board, so that workers, if they want to raise any complaint, or the trade union, if they want to raise any complaint, they can do so. Issue wage slips to workers for each wage period. There is no compromise in this, even for every wage period. For every wage period, maybe daily or weekly or fortnightly or monthly, wage slip provision, providing wage slips is mandatory. Exemption, yeah, small agriculture or domestic workers with 5 or few person. Maybe you have some small domestic workers employed for various works up to 5. The wage the wage slips is being exempted because they work only for intermittent days, and that too for the lesser number of days. And of course, the number will also be very less, and the law says up to 5. So you can avoid all these type of wage slips documentations. Implement documentary compliance checklist. Yes, it's always better you have a documentary compliance where what are the registers to be maintained, whether you are maintaining or not. Put a checklist, display slips, everything. So prepare a proper documentary compliance checklist, and of course, to be more transparent in corporate governance, better you display all these things in the notice board so that every employee and worker come to know that you are complying with the wage code in true letter and spirit. Conduct regular internal audits and corrective actions is always better. Of course, every internal auditors, if it's a statutory internal audit, of course they are supposed to look into all the HR department files. Then they can have an early detection of any deviations in that, and otherwise, it's better you ask your internal auditors to widen their scope and ask them to conduct internal audits of the HR records also. And I should personally advise that all the internal auditors, maybe hereafter, please look into the HR aspects also, the compliances regarding the new code, like wage period compliance, minimum wage rates, wage slips, computation of bonus, computation of all other deductions, and 50% rule. All these things should be ensured by the internal auditors of the company. So any non-compliance can be brought to the notice of the management. And of course, statutory auditors, stat auditors can also have a view on it, if there any non-compliance is there. And say if the company has secretarial audit, obviously the practicing company secretary will look into the compliance of the labor code also. I think it's a whole package. Not only the HR has to work on it, HR has to work on it. Obviously, they are the first-hand responsible person. Of course, finance has to give updated financial statements, and compliance professionals also should coordinate with them. And internal audits should look into this and any early detection of non-compliance, so that there can be a corrective measures very soon. So with this, we are done with the wage code. We had covered the main emphasis on the new wage code. Procedural aspects and administrative aspects we will be detailedly dealing after this law is being implemented in full swing. Maybe at a later point of time we will implement. So please take into important 50% rule, employee definition wider aspects, employer definition wider aspects, time limit of payment of wages regarding to daily, weekly, fortnightly and monthly, bonus computation, deductions computations, and what are the deductions, allowable deductions, and many things which we discussed. I hope that this law is a revolutionary piece, and now practically you need not want to comply with the multiple laws, because now with regarding to wages, bonus, minimum wage, everything, you require to look into only one piece of law, that is the wage code. So I think you will appreciate that single pointed law compliance is required. So with another code, we will come with another webinar. So any clarifications, any feedbacks, please post some comments below this video so that I can take into and I will reply it appropriately. So see you soon with another code. So we are done with 2 webinars. Thank you for your time, and thank you once again, and Happy New Year.